All right, I have reviewed the sentencing verdict, finding no errors or omissions, and I will go ahead and publish the verdict. State of Florida versus Andre Maurice Warner, case number 16 CF-6991. Sentencing verdict: we, the jury, find as follows as to Andre Maurice Warner in this case. As to the aggravating circumstances or factors, we, the jury, unanimously find that the state has established beyond reasonable doubt the existence of the aggravating factor that the defendant was previously convicted of another felony involving the use of the use or threat of use of violence to a person, that is case number CF 11-25469, domestic battery by strangulation, and the jury checked yes. As to number two, we, the jury, unanimously find that the state has established beyond reasonable doubt the existence of the aggravating factor that the defendant was previously convicted of another felony involving the use or threat of violence to a person, case number CF 14-08-255, robbery by intimidation. Jury have checked the option yes. As to factor three, we, the jury, unanimously find that the state has established beyond reasonable doubt the existence of the aggravating factor that the murder was committed while the defendant was engaged in a robbery. The jury checked the option of yes. Number four, we, the jury, find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the murder was committed while the defendant was engaged in a burglary. The jury checked the option of yes. Factor number five, we, the jury, unanimously find that the state has established beyond reasonable doubt the existence of the aggravating factor that the murder was committed for the purpose of avoiding or preventing a lawful arrest, and the jurors have checked yes. Factor six, we, the jury, unanimously find that the state has established beyond reasonable doubt the existence of the aggravating factor that the murder was committed for financial gain. The jury checked the option of yes. Factor seven, we, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the murder was especially heinous, atrocious, or cruel. The jury checked the options of yes. As to Section B, sufficiency of the aggravating factors, reviewing the aggravating factors that we unanimously found to be established beyond reasonable doubt in Section A, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. The jury checked the option of yes. As to Section C, mitigating circumstances, one or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. The jury have checked no. As to Section D, eligibility for the death penalty, we, the jury, unanimously find that the aggravating factors that were proven beyond reasonable doubt in Section A outweigh the mitigating circumstances established in Section C. The jury have checked the option of yes. E, jury verdict as to death penalty, having unanimously found that at least one aggravating factor have been established beyond reasonable doubt in Section A, that the aggravating factors are sufficient to warrant a sentence of death, Section B, and the aggravating factors outweigh the mitigating circumstances, Section D, we, the jury, unanimously find that Andre Maurice Warner should be sentenced to death, and the jury have checked the option of yes. Say we all, this 29th day of June, 2021, signed by Mr. Members of the jury, I'm going to ask each of you individually about the verdict that I just read. The question pertains as to whether the verdict as read was correctly read. In the verdict form is yours. In the verdict form as read is yours. Ladies and gentlemen of the jury, I wish to thank you for your attention, your consideration, and your patience throughout this trial. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by a court order. For many centuries, our society has relied upon juries for consideration of difficult and complex cases such as this one. We have also recognized for hundreds of years that juries' deliberations, discussions, and votes should remain their private business as long as you wish it to be. Therefore, the law gives you this unique privilege not to speak about your jury's work. Although you are at liberty to speak with anyone, if you want to, about your deliberation or about your service. A request may come your way, and people ask you about your service, about your verdict, about your deliberations. That may come from individuals who are simply curious, individuals who maybe try to find fault with what you have done, or simply people who are trying to understand and learn our system. It is up to you individually to decide whether you're going to answer any questions or talk to anyone about your service. From this point forward, you can research us, you can look up any maps, you can look up any definitions, anything you want. It's always difficult as we navigate through jury selection and trials to brag about our democracy, which includes obviously the right to do things and talk about things and read things and discover and explore and investigate things. But when it comes to trials, oftentimes we try to put a lid on that and kindly request for people not to do any of that as it relates to the case. From this point forward, you can do all of that if you want to. So you can look up articles, if any, you can watch court TV, if any, or anything like that, and that is strictly up to you. I sure hope, and I think you've heard me tell other people that during jury selection, sure hope that nothing we have done or the way we have done things that will talk you the next time you get a jury summons from just responding like you did 3.5 weeks ago. We sure hope that this experience have given you maybe, hopefully, a better appreciation of how our system works. You've had the chance to look from within the justice system, the court system, and how we do things. And I've said that on a couple of occasions. What you went through during jury selection and trial is somewhat typical for a case like this. We try to do it as efficiently as we can, but we can only push it so far. We can only rush it so far because we have to slow down and make sure everything is covered. Everything, making sure that the state has its day to have a fair trial, its day in court, and that Mr. Warner has his day in court and have a fair trial. So that's why we're ahead of schedule. We told you we'll be done on or before July 2nd. Luckily, we're able to honor that promise. And it does happen every now and then that cases go beyond what we have expect because of certain difficulties or delays or what have you. So with that in mind, with our sincere thanks on behalf of everybody involved in this case, on behalf of all the judges in our circuit, we would like to thank you and sure hope to see you at the next jury selection when you show up. Have a good day.
All rise.
Please have a seat. Any reason, Mr. Norgard, why this matter shouldn't be scheduled at this point for a Spencer hearing, or should we just go ahead and schedule the status conference and at which time the Spencer hearing can be discussed?
My suggestion would be to set a status conference simply because I do not have my calendar, as I mentioned to you, in a different context. Now that COVID is ending, Mr. Chastain and I have judges setting everything at once. So we need to take a hard look at our calendar. We need to assess and decide what, if any, additional evidence we intend to present. So a lot of moving parts to that. So I think a status conference would be appropriate.
And how far out should I schedule the next status?
If we could set something next week, and if we could do it by, I would appreciate it if we could do it by phone. Just
Steve?
simply for scheduling the Spencer hearing.
I'm sorry,
Just simply for scheduling of the Spencer hearing.
state?
That's fine by the state judge.
Can you get Cindy on the phone, please?
July 7th at 9 o'clock.
Mr. Norgard, Wednesday. Let me check. Hold that thought for a quick second. Okay. Wednesday, July 7th, is that too soon in the morning?
That'll be fine.
Okay. Go ahead and schedule that to be done telephonic at 9:30. Would that work?
Yes, sir.
State?
That's fine by the state.
Is that good with Cindy, 9:30?
She said 9 o'clock?
No, I said 9:30 though.
9:30.
Okay. Mr. Warner, that'll be your next court date, sir, for status. July 7th, that's a Wednesday at 9:30 a.m. It'll be done telephonic. You'll be on the phone. My office will make sure that you're on the phone for that status. State anything else?
No, sir.
Mr. Norgard, anything else?
I was just going to say, between now and then, if we can all get together, agree on the amount of time for Spencer hearing, a date and all that, I don't feel like we would need a status conference, but we just need time to go over how long we think it'll take.
Just, if you're able to do that, send my office an email, copy the state do the same thing. Of course, it's not the state's, I doubt that the state will be presenting anything at a Spencer hearing. So anyway, you guys talk, let me know how much time is needed, how far out we need to schedule that, and if we can get that accomplished, yeah, we can cancel the status of July 7th.
If not, we'll figure it out then.
Yes, sir.
All right, thank you.
All right, thank you, everyone. This hearing is adjourned.
It looked like the defendant was making motions, perhaps to his family. It was hard to see from that angle. This jury, in 4 hours and a minute or two of deliberation, unanimously finds that the 7 aggravating factors they determined were proven by the state beyond a reasonable doubt outweighed any mitigating factors and recommended a sentence of death for this defendant. I am shocked. First word out of my mouth, 4 hours and 1 minute. Thankful to have such experienced colleagues here. Ted Rollins, what are your thoughts when you heard this verdict?
Well, I was shocked, especially that they didn't find any mitigating factors at all in their assessment of this, and they were all like-minded. They did not like this defendant. They didn't like what he did, which I totally understand. And they don't believe that his life was worth saving. And I think Julie brought it up earlier, that moment where the prosecutor Deschamps rolled out the card of evidence, and she did it with such vigor. She said, "This is what the defendant thought of the victim's life, a couple hats and all of this." That might have rung true to them. And at the bottom line is he's got a criminal history, and what he was convicted of was a heinous crime.
And demonstrative aids can make a difference. You're right, that was a powerful statement. Julie Grant, if I could ask you, what's your reaction?
I'm stunned as well, Judge. I really am. Not because the evidence wasn't there. I was saying all along through the penalty phase, when we were going through these aggravators day by day throughout our various shows, I kept saying, I really feel that they all were in alignment with the state's evidence. So yes, I believe the state has presented enough evidence to support them. However, for the reasons I shared before we learned the jury's decision, I really didn't think the jury was going to get there because they weren't the original jury. I just thought 9 days of the penalty phase with not seeing every witness live, not hearing Andre Warner live in the guilt phase, I just really felt like I can't see this jury coming to that decision, such a weighty decision. I mean, the toughest decision you could imagine one having to undertake, being called to serve as a juror in America, and they made it in 4 hours. So I am incredibly shocked. Yes, I think the evidence warrants it, but in this case, I really feel like I didn't see it coming because this was a penalty phase with a different jury, and there were some questions raised by this defense team. As I said before, I think these advocates on both sides did an outstanding job. And for our viewers, if I may, Judge, just add one thing. We heard them talking about that Spencer hearing, and I remember this coming up in some other cases that we had in Florida, and that is a case where before a sentence is entered by the judge, when there's been a death penalty recommendation, the defense will have an opportunity to present more evidence. The defendant has an opportunity to address the court. You heard his counsel talking about how we need to set a date for that hearing. So before it's entered in by the judge and the judge accepts that recommendation and makes it official, so to speak, there is one more last-ditch effort, and it's named after a case in Florida involving someone named Spencer, so that's why they call it the Spencer hearing. So I just wanted to clarify that for anybody at home who may be wondering about that, Judge Ashley.
No, that's a great legal point. And Julie, my understanding of the Spencer hearing is if they present more evidence, it's not to do it to another jury or the same jury, but rather the judge to convince the judge not to accept the recommended death sentence, but rather to order life as the sentence. Did I get that right, Julie? That's my understanding.
Judge. You sure did. You're spot on that, yes.
So a little bit of information from the courtroom, from our field team. Apparently, the defendant told his mother, we saw him turn around in motion, that he loved her. She started crying, and then you could see that he was taken from the courtroom.